Joining me right now, Sheryl Hunter with Hunter Business Law. We're talking about a practice that we're seeing more and more of these days, class action lawsuits, what they mean, who benefits, who doesn't. Good to see you, Sheryl. Thank you for stopping by.
Thanks for having me.
Well, let's start out with definitions, as we always do when we talk about legal terms. Tell me what a class action lawsuit is.
Well, class action is just what it sounds like. It's a class of individuals who are under a common situation, who join together. There's an attorney that brings them together, identifies this class of people, and there's usually representative plaintiffs. So maybe two people out of a class that can be tens of thousands of individuals who have a particular situation, and then the lawsuit is filed as a class action. So,
now, who determines whether it can be a class action? Because I know there's a difference.
Sure. Well, initially it's brought to a plaintiff's attorney who typically specializes in class action lawsuits. And that plaintiff's attorney will examine the facts and the circumstances to determine how likely it is that this group of individuals can be certified as a class. You have to actually go through a process of showing the court that these individuals have enough commonality of facts and circumstances and damages that it makes sense to bring them together to collectively bring a lawsuit.
Now, so who benefits the most on this? And I'll throw something at you after you answer that question first. Who benefits the most?
Loaded question now, right?
Who benefits the most? Does the individual that's suing, the individual that's being sued, or, and I'm kind of saying this because we see a lot of class action lawsuits, or is it the law firm that doesn't have to do nearly as much work because all they have to do is prove it once, and then they get the settlement from all these other people?
Well, I would say it's a lot of work on the plaintiff's side as well to bring a class action.
Okay,
So
I know it's right.
Yeah, it is actually a lot of work and expense, but it kind of depends on who you ask on who is most likely to benefit. But there's no doubt that bringing a class action gives you tremendous leverage against a defendant in the case. So I know we were going to talk a little bit about some current Supreme Court cases, and one of them is the right of employees to bring class actions against employers, and whether or not employers, when they hire those employees, can require them to waive their right to bring collective action. So let's take a situation like right now. One of the cases is Morris versus Ernst & Young. So Ernst & Young is a very large accounting firm, obviously.
Oh, sure, heard of them a lot, yeah.
Yeah, so Stephen Morris and Kelly McDaniel brought a class action in federal court, a representative of tens of thousands of other accountants saying that they were misclassified and they should have been paid overtime for all these different hours that they'd worked. Okay, so this would be an example of a class action, right? So if they brought those as individualized claims, it's probably not a lot of money, maybe $20,000 a year, I'm estimating, for overtime that maybe they should have been paid that they weren't paid.
Sure.
Individualized, you know, how exciting is that claim? How much is the defendant going to shake in their shoes over that? Versus you've got tens of thousands of people with potential for 20,000 and up claims. You multiply that out, and that likelihood that Ernst & Young or a defendant in a similar situation is going to settle with the pressure of a class action is much, much higher. And a lot of people call it blackmail settlements once this class is certified.
Because we're talking about settlements, and I'm just thinking in my mind, you know, 20, 30, 40, 50, and on up, millions of dollars.
Yes, millions of dollars. And the risk that potentially that class could result in those types of damages. And keep in mind that the other individuals, those other tens of thousands, the representatives are 2, 10, maybe 15 more people who are the named plaintiffs. All the other people don't really have to do anything.
Yeah.
It's sort of, you've probably gotten it before, maybe when you own a stock, you know, and you have the right to opt out of the class, but typically like, I'll just be in the class, I guess, and maybe they'll send me a check.
Well, I do.
You know, or
I do just the opposite because I don't remember buying anything from them.
And most people don't, or they figure maybe I don't own very much stock in anything, so maybe I'll get $10. I'm not going to do it.
So let's step back. So now companies are trying to be proactive because they would rather not have class action lawsuits. What are they doing to try to prevent that?
So they're putting in their employment agreements when somebody joins the company, or if they want to have ongoing employment, they'll say you need to sign this document. Those documents contain language that say you have to bring individualized arbitration claims. You have to have your claims heard in an arbitration setting, not a court of law, and you're waiving your right to collective or class action. So in that same example, which is a real case, the individual Stephen Morris, the individual Kelly McDaniel would have to bring their own claim in an arbitration setting. And arbitration, because it's not public court, is a private, quiet setting. There's no public record.
Right, so it wouldn't be necessarily embarrassing for the big employer.
Correct, and other employees may never know anything about it. It's typically a confidential settlement. So people who think that's wrong believe that it doesn't publicize wrongdoing by an employer, and therefore it never gets remedied.
And the court will be making a decision that will affect all the companies then, right?
Correct. The court heard oral argument on October 2nd, and it was 3 consolidated cases. And the reason this got heard by the Supreme Court in the first place is there's a split in the federal courts between the 2nd Circuit, the 5th Circuit, and the 8th Circuit, on one hand saying that this is legal and it's enforceable, and then the 7th and the 9th Circuit said that this waiver of class action rights is a violation of the National Labor Rights Act.
Can they make you sign something or not sign something after you've already started working with them?
Yes, you can basically,
That's
as a condition of ongoing employment. Now there's different state rights that maybe that violates. It's kind of beyond the scope of my ability to discuss that today, but yes, sometimes it's if you want continued employment, you need to sign off.
Now, is there a question about whether you sign in or whether you opt out? Because this is another thing that I know some companies are trying to deal with. So if you get a piece of paper, it says, "Hi, we're going to go to this arbitration process," and if you don't sign out to opt out, that you are now bound by that.
You know, I don't know whether there's this would be state specific as well as federal law, and I haven't looked at the opt-in, opt-out. My recommendation to an employer would be to have people sign those documents, not just by not signing that they're accepting it.
So sign to opt out would be the recommendation, or sign to opt in.
Well, I don't think the employers are giving them the option in these cases.
Can
I mean,
they do that
saying,
when they kind of don't give you an option?
Can they do?
Yeah. Can they still do that if they don't give you the option?
Well, you don't have to work there is probably what they would say. Like, if you don't want to sign this, then you don't have to work here. But the real reason that these cases are, this particular group of cases in front of the Supreme Court right now, most employment lawyers believe this is one of the most critical cases in the last 20 years.
Oh, gosh.
Because it will impact, the rights of employees to bring collective action.
Yeah, and can you surrender your rights if you didn't, in quotes, sign them away? That's
well, and it really comes down to whether the Supreme Court believes that the National Labor Relations Act protects. It has language that says concerted activity among workers is protected. So is this concerted activity that's protected?
With Gorsuch, is this expected to lean one way or another, conservative, liberal? Really not.
Oh yes, there's definitely belief that they'll cut between liberal and conservative lines, and there's also belief that Kennedy would be pro-employer, believe that it's a contractual right, that an employer has the right to require contractual terms with employees.
Yeah.
Most people believe Anthony Kennedy will have the decision.
I can't tell you how many times I've interviewed people that go, "Well, Kennedy's got the swing vote. Kennedy's got the swing vote."
I know, and I think it's always speculative. People watch oral argument and they try to speculate.
Sheryl Hunter, Hunter Business Law. We'll just have to see where this comes down, and when it does come down, we'll bring you back on and talk about it again.
Okay, great. Thank you so much.